3, 2, 1.
So we have a great panel session today. The Keystone Contractors Association, the Education Committee has come up with an employer educational session, a series of sessions, but this one is evolving drug use risks in construction. Before we start, the speakers are going to tell you about themselves a little bit and their company. I'll let Lisa take over.
All right, next slide.
There we go. Thanks, Lisa. Thanks, KCA, for putting on this educational series. My name is Darren Rech. I'm the Safety Director at Alexander Building Construction here in Harrisburg. We're a Blitz family company. Just a little background about myself. Graduated a long time ago from Indiana University of Pennsylvania, Bachelor of Science in Safety Science. I have a master's in business administration from Penn State. Certified safety professional. We do OSHA outreach training, authorized construction trainer, and just a lot of years in different leadership roles in various industries, manufacturing, insurance, mining, etc. Currently, just a lot of what I do is employee safety training, incident investigation, OSHA record keeping, workers' comp type issues, and safety audits on all of our construction projects here in central Pennsylvania, Harrisburg area. So with that, I'll turn it over to Tim.
Thanks, Darren. Good afternoon, everyone. Thanks, KCA, for allowing me to be part of this panel. So I'm Tim Ziegler with McConkey Insurance and Benefits. We're an insurance broker and risk management firm in central PA. Been around for 130 years, so we've seen a lot of changes, but as with anything else in business, there's certainly new stuff like medical marijuana issues that are popping up. So my role here, I oversee our construction and surety division. I've been here about 10 years. Prior to McConkey, I was an underwriter and claims adjuster for Travelers Insurance. Part of my role, working with clients on anything risk management related, from insurance placement, claims issues, in negotiating project terms for project-specific policies. So happy to be here and looking forward to the discussion. So, Lisa.
Thanks. Hi, good afternoon, everyone. I'm Lisa Koblin. I am an attorney with Saul Ewing, and I work in our labor and employment group, which means I get to assist construction clients and clients in a lot of different industries, big, small, all over the state and actually all over the country, with all the fun legal HR stuff that happens that no one really wants to deal with and no one really knows what to do with. I end up getting a lot of those calls. And so my job is to help business owners, HR, managers, just kind of figure out, okay, what is the law? What do we have to do? Where do we have flexibility? How am I going to not get sued? And if you do get sued, we're there to defend you and represent you in litigation as well. I also provide, handbooks, policies, advice on drug testing, of course, which we're going to talk about today. And I've also represented some clients in some OSHA related citation matters too. If you could go to the next slide, that'd be great. So we're going to primarily focus on marijuana in the workplace today because it's a really hot topic. We know that it comes up pretty frequently and it's not going to go anywhere as marijuana continues to become legalized in different states across the country. I think Pennsylvania is going to follow suit pretty soon as well. And I also just want to say that, we have a pretty kind of casual format here. We have definitely a lot of slides with good information, but if anybody has a question, a comment, wants to chime in, wants to share something, please feel free to do that. And I'm going to be working with Tim and Darren to, kind of incorporate them in their wealth of knowledge and experience as we talk as well, and then throw in all the fun legal stuff that is actually really important and hopefully will make sense to everyone. So just to kind of kick it off, we do want to just, it goes without saying that marijuana or drug use, certainly has a big impact on the workplace, but marijuana is particularly difficult because in some situations for certain employees, it's permitted, for others, it's not. Nobody wants to have anybody high at work, but these things are happening more and more, and it can impact your business in a lot of different respects, whether it's your hiring, whether it's you suspect that somebody's impaired at work, training, security. It takes a lot of different shapes and forms. So it's important to know, what the rules are, and, do you have a policy? Why should you have a policy? Things like that. Next slide. So we like to include a little stats here and there when we can, and I apologize because I forget at this point where I pulled this from, but when there is a substance abuse issue, or when there is drug use, it's going to impact the workplace in a lot of different ways. It makes workers less productive. You're going to have absences, you're going to have turnover, you're going to have accidents, and that's a really big one. And of course, on a construction site, if you do anything related to construction or any industry that involves, safety sensitive roles, these are the kinds of things that we can't really afford. Especially, there's a risk already just in the job that you're doing, and then we know that there's an increased risk. And Darren, I'm just curious, in your practice, how often do you hear from, the contractors that you work, or the construction folks that you work with, about the concern about drug use on the work site, people being impaired? Is that something that you're hearing about that's coming up on a regular basis?
Yeah, absolutely, Lisa. I mean, more and more, we originally had started out years ago with a drug policy. And just a little, if I can digress for a minute, Alexander we're a construction manager, so we're not doing as much work on site. We are managing contractors. So, a lot of our policy is what we require from our subcontractors and their employees and their, lower tier subs. So, it continues to be a question of, there's a lot of questions, and we continue to evolve. We have a policy that we started probably 4 or 5 years ago. And maybe we'll get into that a little bit more as we go, but we've evolved, and we've kind of revised this policy a couple times over the last several years. And, obviously with the topic we're talking about now with marijuana, it's going to continue to be revised. So yeah, a lot of questions. It's good to have this panel where we can kind of bounce ideas. And what are you guys hearing from the law side? And, Tim, what are you hearing from the insurance side? So I think it's a conversation that's ongoing.
Yeah, and on that note, Tim, I'm just curious from the insurance standpoint, obviously we're going to get more into kind of the different types of policies, but are you seeing any sort of increase or trends in your policyholders interesting or reporting claims that are related to, injuries related to drug use, or, suspicion related to drug use? Are you seeing any of that come up more often now?
Fortunately, I mean, we've seen a little bit of it, but no major trends, which is good. I mean, the one difficult thing about marijuana is sometimes it's not as easy to notice when an employee is impaired compared to alcohol, when they're slurring their words or they smell like booze. So, fortunately, haven't seen a big increase in it across the board.
That's good. Hopefully it'll stay that way. Next slide, please. All right. So one of the reasons why this has become more of an issue and a topic from the legal perspective is that, there's even though we're going to talk about that marijuana is still illegal under federal law, medical marijuana is permitted in Pennsylvania, and soon it's going to be adult use too, right? So where have we seen these issues come up? It's when an employer violates the state's medical marijuana discrimination provision, meaning that in some way, shape, or form, we're deciding that someone shouldn't be hired, should be fired, can't do a job because they use medical marijuana, or we violated the law because medical cannabis was a treatment for a disability and they should have been accommodated and we didn't accommodate. So there's going to be situations, it's not a one size fits all, but there are situations where employees, if they're using a medical marijuana as prescribed outside of work and that information comes to light, that may result in needing some sort of an accommodation so they can do their job and not be impaired at work. And it's a process that you have to go through. So one thing we're going to talk about is if you have a policy or you're thinking about dealing with this issue, making sure we're not just having a gut reaction of someone told me that they, use marijuana outside of work and therefore they're going to show up high. I can't have this. It's a risk and I'm just going to let them go because I don't want to deal with it. And certainly it's understandable that you don't want to put anyone at risk and you don't want to have that frustration. But the laws in Pennsylvania tell us that we need to stop, we need to pause, we need to evaluate, and we can't just make those snap judgments, because that's how you're going to wind up getting sued and spending a lot of money. And as much as, listen, I'm an attorney and I like making money, but I really do try to help people avoid ending up in a courtroom when I can. It's not a good use of anyone's time or resources. Next slide. So as I mentioned, I think it's no secret to anyone here that marijuana is still legal under federal law. I don't know if and when that will change. Certainly in this administration, they're going to view it differently than the prior administration, but we have no way to know at this point if it's going to be removed from the list under the CSA. And so that's going to impact, CDL licensed employees and employees in certain safety sensitive roles that are governed by the federal government. Okay, so this is, again, remember, not a one size fits all. In some states that don't have medical marijuana laws, there's fewer and fewer of those, but then marijuana is just straight up illegal, right? There's no ifs, ands, or buts, it's just illegal. But when we're in a state where medical marijuana is permitted, then there's another layer here. Next slide. Another thing to be aware of, I don't think this again will shock anyone, but medical marijuana is actually currently legal in about 38 states. And in the past few years, there's been an increase in the number of patients who are expected to use it annually. If anyone has looked into what it takes to get a medical marijuana card in Pennsylvania, it's really almost any condition under the sun that you go to a doctor and talk about. So it's not like a heightened standard for a very specific type of cancer or certain types of disabilities. You can have reoccurring migraines and get a prescription. And a lot of people do feel like it is a very effective treatment. So we're only going to see an increase in those patterns. And I think that it's going to actually be safer to assume when you're interviewing, you're hiring people, you're working with people, that some percent of your workforce has a prescription for medical marijuana, because that's just the rate that we're seeing these prescriptions being doled out. Next slide. So back in 2016 in PA, the governor passed the Medical Marijuana Act, otherwise known as the MMA, and then it opened a registry, and you'll see, there's the dispensaries around the state. You can go to the next slide. And you can just see these statistics again are a little bit dated, but you can see the trend that by 2019, after the dispensaries were set up, there were already, over 100,000 patients, with the rates growing by 9,000 people a month. And, that rate is significantly higher now. And as I mentioned, it's very, very easy to get a medical marijuana card. Now, if somebody just uses medical marijuana, if somebody uses marijuana to treat a condition, but they do not have a prescription and they don't have a card, and an issue comes up, we'll talk about this, but they're not using marijuana legally under the law. So there is a distinction. So if you have a situation where someone tests positive for marijuana, especially after some sort of impairment or issue, and they don't have proof that they're, using a prescription, then they're using an illegal substance and they can be treated as such, right? So there is a distinction. But really importantly, under the MMA, employers cannot fire, threaten, or refuse to hire or otherwise discriminate or retaliate against an employee because of their status as a person who uses medical marijuana. So when you're doing your hiring and you're going through that process, if someone discloses that they are a medical marijuana user, unless they're in a very specific subset of positions that are regulated by the federal government, which specifically require that the person not use a controlled substance under federal law, we can't just decide not to hire them because they're a medical marijuana user. At the same time, we're not required to just allow people to show up impaired at work or to use marijuana at work or just have it on them or distribute it or anything like that. It's really about distinguishing between somebody who has a prescription for marijuana, who goes home, uses it at night, they wake up in the morning, they come to work, and they're not impaired and they're ready to do their job. versus, people showing up impaired on the job. There's a really big difference. So just understand that, again, we don't want to rush to those snap judgments if we learn that someone, may be using marijuana in their spare time. Next slide. So I do want to be really clear about all the many exceptions to that standard under Pennsylvania law. So as I said, we're not required to accommodate or allow someone to use marijuana, whether they have a prescription or not. It doesn't matter if they're literally holding their prescription in front of your face. They're not allowed to come to work and smoke on the job or, use a pen or whatever, however they consume marijuana. They're not permitted to do that at work. You can discipline someone who's under the influence or terminate someone if they're under the influence. We're going to talk about what that looks like. And also, PA law does not require an employer to commit an act that would put the employer or that person in violation of federal law. So again, we'll talk about kind of CDL and other specific safety sensitive roles. If the federal government has said this very specific position cannot, they're going to be drug tested and they cannot be consuming any of these controlled substances, then we can treat them differently. But that's a really narrow, even in construction and a lot of industries, it's still a kind of a narrow carve out. And you can prohibit someone who is a medical marijuana user from doing anything that you would think would be like life-threatening or cause a safety risk to other people, while they're under the influence of medical marijuana. And that's where that accommodation piece comes in. So if you learn, whether through a random test or some other way, that someone might test positive for marijuana, but they have that prescription prescribed by their doctor, they need it for a condition, then we're going to want to go through an interactive process and figure out if the person can do the job in a safe way. It looks like there is a question in the chat. I can't.
Here, I have it, Lisa.
Okay.
It's a long one, but Mayon is asking, is there a drug test currently on the market that can prove a worker's psychoactive high state when testing for THC? In an example, she mentioned a painter working on a construction site has a medical marijuana card, falls walking down steps and becomes injured. When post-accident drug testing is performed, you can determine the worker smoked over lunch versus before bed. Can you prove
let's just pause there with that first kind of group of questions, because I see that there's a few, and this is great. And we're happy to kind of talk through these. And I would love to also, I'll respond and love to hear Darren's experience if he's dealt with anything like this before. But the short answer is that technology is not there yet. So the way that we can test for alcohol and know basically how recently someone consumed alcohol and that they're impaired by alcohol because they're because the alcohol, the breathalyzer shows that their blood alcohol level is at a certain rate. We don't have that yet for marijuana. And that's one of the reasons why showing that someone is impaired is the most critical piece of the puzzle for most workers. So the test is helpful because after you know that there's impairment, it's kind of back up to what you suspected. But a drug test alone, if someone tests positive for marijuana, they could have had marijuana hours, minutes ago, hours ago, or days ago. So it's really not the same as alcohol yet. I know that that's something that a number of different drug testing companies are, I'm sure, working on day and night, because when they figure out, the magic sauce, it's going to be a big deal, but we're just not there yet. And so in your example about a painter who falls down the steps, you would want to figure out, did anybody see how the person fell, see what caused the fall, talk to the painter, and look for physical signs of impairment. Like, do they have bloodshot eyes? Do they seem like they're not coordinated? Do they seem like they're, kind of out of it? Do they smell like weed? All that kind of stuff. And that is what's going to help you figure out, what is most likely to have caused that injury. Was it they just slipped and they were doing their job, but it was an accident? Or is it something more than that? What, do they have a history of kind of suspicious activity? Did anyone else see them that day acting strange? All that kind of stuff. So it's really its own kind of mini investigation. Darren, have you had any experience where you had to kind of go and help, try to figure out whether someone's been impaired at work or how to respond in that moment where there's been an accident where you suspect that marijuana or some other substance is involved?
Yeah, we our superintendents are trained in reasonable suspicion training, and I think that's where you were going with this, right? With the signs and symptoms. And so we, fortunately, we haven't had much, at least in central Pennsylvania. And Mayone asked this question. She's a coworker of mine with Alexander in the State College region. And so, there may be examples up there, but I can't say, at least here, we've had a case where it was a post-accident or a reasonable suspicion type testing that we ran across anybody who was, had the symptoms or the signs of marijuana use or alcohol use, to be honest. Now, the question too, I guess maybe for you, Lisa, is, if this person hypothetically would have came to us and said, "Hey, here's my medical card," then it's incumbent upon the employer to accommodate that person to a task. I'm assuming that is, so we're not discriminating, but that person is not doing a safety sensitive task. Is that accurate to assume?
In most ways, yes. So I think at that point, what we want to do is find out from their treating provider, based on their job duties, not getting into like medical history and diagnosis, but just based on their job duties, are they able to perform this job with or without some sort of accommodation? And so if they have to, for example, take marijuana, however, at, I don't know, 10 in the morning, and then again before bed, and that would cause them to be impaired at work. First of all, you don't have to allow anybody to be impaired at work, but the doctor would have to explore whether there's another treatment option or something that they can do to help the person not be impaired. And otherwise, if there's a concern about safety, you could examine, I guess, whether there's a way to adjust the position or think about a transfer, but ultimately you're not required to change the role for which they were hired. So there's a difference between, tweaking some parts of the job to make it so that someone can do their core job duties and changing the role entirely. So I would just say that, it is a process. It's a little different for every case, but you don't have to just kind of create a new job or find a new job that isn't available because of this type of issue, if that makes sense. And I see that there's some other, I think I can see them now.
Yeah.
There's some other questions in the chat. I'm just going to keep answering the first one from Mayone, and then Melissa, I see your question too. It says, all right, we talked about that one. Can you prove the worker was in fact impaired? At what point is the employer at risk and crossing the line with workers' rights having a medical card? Mayo, maybe you can explain your question a little bit there. It's okay. I mean, I guess, I don't know if this answers your question, but if at any time you're drug testing someone because of reasonable suspicion, like you would in this case, if they have a positive show up, they should be given an opportunity to verify if the positive is based on a prescription. And so they would, give proof to show, like, if marijuana is going to show up on the drug test, that marijuana is there for a permissible purpose. If they can't prove that they have a prescription, that they have a card following the Pennsylvania rules, then they've just, taken marijuana in a way that's not permitted by law. And you don't have to treat them as, disabled or give them any kind of special accommodations because they're not using marijuana as prescribed. Does that answer your question?
Yeah, a little bit. I think I'm really referring to, when a worker has a card, like there's a couple things. One, should we as a construction manager who implement drug and alcohol policies on sites incorporate testing for THC or eliminate it at this time, since there's no real way to test an employee's psychoactive state? So we're really relying on reasonable suspicion to prove that an employee or a worker was impaired at the time of an incident or may contributed to an incident or an accident, right?
Yeah,
it-
so I'll answer that question first. There is a trend. So there are certain places like New York City, for example, where you just can't test for marijuana because it's legal. The test results should not be indicative of whether or not someone was impaired. And unless you work, again, in a very niche area that's covered by the DOT and the federal government, the test results showing marijuana shouldn't matter. So I actually have seen a trend in clients who don't even test for marijuana because they know they need to rely on impairment and they don't want to open the door to an allegation from somebody who is a medical marijuana user that they're making a decision based on test results. That being said, you absolutely still can test for it and kind of use it as, think of it as like backup to support an impairment decision, but it shouldn't stand by itself. And then, of course, there is that caveat, like I keep saying, just for there's a couple positions that are regulated by the federal government where you do have to test for marijuana. So those are treated differently.
So with construction in construction safety risks, essentially, any site at any given time has, moving equipment, working at heights, and a bunch of different, safety sensitive positions, we would say. How does that play out with, towing the line between medical marijuana users and trying to accommodate them, but also, you may be a painter and walk out of the site and there's equipment moving and they get hit, right? Because they weren't aware of their surroundings. Like, how do you manage that risk?
Well, I would say in general, if someone's in a safety sensitive role or they're working on a site that has inherent safety risks, it makes it a lot less likely that you can accommodate any circumstance where someone could have some lingering side effects from marijuana or frankly other, codeine or, muscle relaxers or other substances that would impact someone in a similar way. So I think you have to take it one step at a time. Like, you're not going to go survey people or, reach out and ask questions before an issue comes up. But if someone raises an issue, you have to figure out, what their job is, what their doctor is saying, going over the duties. And I've found in a lot of times, if someone wants to keep their job, they will try to find another way with their doctor to make it work. And if at the end of the day that can't happen, you certainly need to keep the workplace safe for everyone. And if it seems like there's not a way to do that, there can be situations where the accommodation request is denied or someone's not fit for a position. That is sort of a last resort. And I would just say, and we can also talk offline if you have more detailed questions, but I would just say it is a step-by-step process and it really depends on the position and what the doctor is saying. And when push comes to shove and we're saying, listen, we want this person to be able to work, but here's what we need them to be able to do. And here's where they work, we need to find a way to ensure the safety of our employees and of the individual. Usually you can find a resolution that, will make everyone feel better, I guess is what I'm getting at.
Okay, thank you. It definitely is a struggle for, construction management firms that have a bunch of different activities going on one site. It just
Sure.
takes them, working on a ladder, falling off, or walking into an area that they shouldn't,
Yeah, absolutely. 100%. Fully appreciate that and really appreciate your perspective and sharing. And then I didn't want to forget about Melissa's question. She asked, what are the insurance implications for someone who tests positive after an accident but shows no signs of impairment, i.e. someone has a car accident, tests positive, but isn't impaired? Tam, I'll go to you first. Do you have anything to add from the insurance side there?
Yeah, so the insurance piece of this is relatively straightforward. Typically, just because you have a positive test doesn't mean a claim is going to be denied. So in the situation of the painter, just because a painter tests positive and then was injured doesn't mean that claim is going to be denied, and it's very likely that claim would be covered by workers' comp. Getting into Lisa's field with the law a little bit here, but really the case law in workers' comp is you almost have to prove that the proximate cause, or almost the only cause, was that they were impaired. If not for them being impaired, then they wouldn't have been injured. So if you can prove that, which is a pretty high standard, then you could deny a claim. The Pennsylvania workers' comp system is very employee friendly. So I'd say if you're an employer, you really have a hard time getting a denial to stick. From an auto accident standpoint, if you're the business owner and the employee tests positive after getting in an accident, it's very likely the insurance company will still cover the claim. It's not common for there to be, an exclusion that would be specific to employees that are, involved in accidents that have their medical card. I don't think I've seen one of those exclusions. You can have driver exclusions on policies, and I know those are sometimes tough to enforce. But that could be certainly one if it's an employee who has had a history of DUIs. The insurance company puts a driver exclusion and then he gets in an accident, then, that doesn't have anything to do with the impairment, but that could be a way where the claim wouldn't be covered. But outside of those situations, we don't see claims getting denied because of, whether it's medical marijuana or alcohol use.
Thanks, Tim. That was really helpful. Thanks for sharing. And you guys can continue, obviously, to put your questions in the chat, and we'll continue to answer them as we go. And or at the end, I think we'll all stay on for a minute if anyone else has questions then. If we could go to the next slide, please, that'd be great. Okay, so just to recap on the adult use, currently in Pennsylvania, adult use outside of a medical marijuana prescription is still illegal. I just saw that a couple weeks ago, there was movement in terms of bipartisan legislation that's being introduced to allow for adult use over the age of 21, as well as the sale of marijuana in the state. Obviously, Pennsylvania has been impacted by New York and New Jersey making a lot of money from the sale of marijuana, and it seems like the state at some point will follow suit. I don't know exactly how soon, but I imagine that we'll see legal adult use coming to Pennsylvania in the not too distant future. Next slide. So in Pennsylvania, every state is a little different. In Pennsylvania, there really is not a law regulating pre-employment drug testing or drug and alcohol testing and employment outside of some federal rules and regulations. Generally, you can choose to implement drug testing program that works for you. We're going to talk about policies. What I would say is I think it's really important that your policies, your application materials, whatever you're giving to your employees in writing reflects what you actually do. Because I've seen a lot of cases where there's really outdated policies, or policies that someone just, they kind of pulled a handbook off the internet or got one from, ADP or something, and it doesn't really actually reflect what they do. And then an issue comes up and an employer or manager says, oh, what do we do here? Our policy says we have to do A, B, and C. And you're like, we've never done that, in the history of the company. What are you talking about? It creates confusion, it creates inconsistency, and we don't like that, especially from a legal perspective. So that's really key. Just, making sure that you do have something in writing that reflects what you're going to do in practice. Next slide. When you have a policy, and if you do any sort of drug testing, you should have a policy to explain just at least an overview of what your process is. It doesn't have to be super nitty gritty, except for federal contractors in some cases. But it should, again, tell people what to expect, when drug testing is going to be required. So some companies do random testing, some don't. Talking about reasonable suspicion, confidentiality of test results, things like that. And I know, Darren, I think you had worked on drug testing policies throughout your career, and you mentioned kind of updating yours. Do you want to kind of walk us through a little bit what you've thought about from your perspective in terms of updating and implementing a drug testing policy?
Yeah, so just some background story. I mentioned earlier that we had sort of a pilot program, drug and alcohol policy. And we implemented it just to see the pros and cons of this policy. And, we had some takeaways. It was really a cumbersome policy to implement. And again, as I mentioned, we are, as a CM, we required this from all of our subcontractors on this particular job. And just some of the components were like testing within 24 hours before starting work, before you jump on site. And testing was permitted only at one approved testing facility that we had mentioned in our policy. So those are a couple of things that really kind of clouded the situation. We discovered that, we have contractors traveling from long distances and they have to get in town maybe a day earlier just to do their drug and alcohol testing before they can show up the next morning on site. So that was a little cumbersome, and even just the delays in getting results to the project team and making sure that this person is clear to work. So we try to create something a little more user-friendly, if you will. And so we implemented a policy that we have a standard, and it does not include marijuana. So it's a 9-panel test, basically 10-panel test without marijuana. And so we required all of our subcontractors, second tier subs, to be tested within the last 12 months in 9-panel test. And we required a notarized letter for employee A through Z stating that they have this drug and alcohol test. We weren't actually looking for results. We're just kind of pushing it down to the subcontractors, right? And so, we certainly have some gaps we realized, but we felt it was an improvement from the original policy, and we felt something's better than nothing. And that's just what we would do on maybe a project that we're running that the owner or the client doesn't have their own requirements, right? So that's where we landed so far. And we're just really trying to deter a subcontractor by sending an employee they may feel is hot, or is hot, just that they know it from their previous drug testing. Are there gaps? Yeah, certainly, but that's kind of where we landed. And I'd be curious to hear if anybody else has any input, something different that they're doing. But that's kind of what that's where we're at so far. And as I mentioned earlier, this continues to evolve. So, anything we can improve on, we're certainly open to that.
Great. Thanks for sharing, Darren. And then, of course, if anyone wants to jump in the chat or share or give their own feedback or experience, we're happy to talk that through. But I think you hit on a couple key points, which is, it's a process that's evolving. It seemed like you put in kind of a test policy, then you've been tweaking it based on, what's actually going to work for you and the contractors and subs that you work with. Because again, if you have something in writing that just is not going to, play out, it's going to create delays, it's going to create confusion, it's not helping anyone. So I think kind of reviewing and revisiting it as you go is really important, and just being in communication with people about it. And then the other big factor that you said, which is a big reason for the policy. And also, by the way, if anyone puts information on drug testing on the applications, this is in some of our slides too, deterrence is huge. I mean, you don't want people, you want to let people know from the get-go in bold, hey, we may drug test you. It may come up. Here's when it may happen. You should be prepared, so that the people who might be inclined to, use substances that they don't have a prescription for, that they're not using validly, to not want to come work for you because it's going to create those safety hazards. So we want to be really clear. It shouldn't be, other than, random testing, which happens randomly, the fact that you're drug testing shouldn't be a surprise to people. That's not helpful.
Yeah, and just to add to that too, Lisa, we often are on projects that, we may have a project team that does not include a full-time safety rep on that particular job. So, to manage a program, we're relying on that project team, which may be for 3 or 4 people, someone like that. So, that's also, what we find that we're up against is, is this something we can really administer and we can manage, internally?
Absolutely. All right, next slide, please. So you absolutely can have, continue to have a drug-free workplace policy if that's part of your practice. It can be, I've seen some that are a paragraph, and I've seen some that are multiple pages, depending on the industry that you're in and you know, how you go through the process and how detailed you want to be. But it is there really to protect the company and to put people on notice about what it is that you're going to do. You know, so if you're going to be sent to a testing site, how soon you need to report, that, you know, you're not to return to your, if it's reasonable suspicion, you know, not to return to your position until you're told otherwise. And then making sure that your policies are applied consistently is really critical, because in my line of work, a lot of problems come from perception that people are being treated differently than someone else, even if it's not really true. If we're, you know, letting someone slide because they're a longtime employee and they're friends with our cousin and we think they're really funny, but someone else does the exact same thing, we're putting them through, you know, a 10-step process, and one person happens to be a man and one person happens to be a woman, or one person happens to be Hispanic and one person happens to be Caucasian. You know, people are going to start to wonder, well, why is this happening to to me and not to them? And so to reduce the risk that those kind of questions are going to come up, people are going to feel that they're being treated differently, consistency is really key. And then, of course, making sure that our policies don't say things like, if you test positive, you will be terminated, right? Because somebody could test positive for a prescribed medication, you know, setting marijuana aside, there's many other medications that people take for legitimate injuries and issues that could show up on a drug screening, depending on what it is. And if they have a prescription and they have the proof from the doctor that it's a valid prescription, if you terminate that person solely because of the drug test result, setting aside, you know, impairment in the workplace, but if you terminate them just because of a positive result, you're likely going to have a disability discrimination lawsuit on your hands. So I have seen that in a number of policies. We want to modify that to say something like, if you have a positive test, you know, we may pursue disciplinary action consistent with the law, something like that, right? Just to make it a little bit broader. And then the other thing we keep talking about is making sure that our supervisors and our managers are trained in detecting current intoxication, because kind of capturing what's happening in the moment is so critical. I just had a call from a client the other day about somebody who is in a driver position, and they showed up to a work site where a manager happened to be. They had bloodshot eyes. They were slurring their words. They'd already been driving from site to site, and the manager took the person right to the hospital to I forget, some sort of medical facility to be tested. You know, was because the manager, and this person did not have a history of this type of issue, but was on alert of, you know, this isn't just somebody's a little overtired or somebody isn't feeling well, like there's something really wrong here. And then HR worked with the manager to document what was seen. And, you know, now we're in the process of, you know, that person ultimately is going to go for fitness for duty based on what has been found out. So it's really, really important to talk through that process. Next slide. And some other points to consider about your drug testing, you know, you do have to obtain consent from someone. If the employee or prospective employee refuses to do the drug testing, that certainly can be a grounds for termination or grounds not to hire, depending on what the reason for the test is in your process. But it's not something we can actually force on anyone. And, you know, we do want to make sure that when we're drug testing, we're weeding out legitimate prescriptions, so we're not, you know, impacting people with disabilities in a disproportionate way. And like I said before, tell people right up front that you're going to drug test. You will weed out people through that deterrent factor that you don't even know about. So it'll be really helpful. Next slide. One thing to be aware of, I don't know that this impacts anyone here, but just in case anybody ends up doing any work in Philadelphia, there is a specific rule in Philadelphia only that there's no pre-employment drug testing for cannabis. So if you're based in Harrisburg, but you're going to have somebody working in Philadelphia and that's where they're going to be working, this rule will apply to you, even if your home base is in Harrisburg, for that person, not for everyone, but for the person working in Philadelphia. It's like New York City. So for pre-employment, unless you have a CDL or you're on some sort of federal government contract that very specifically requires cannabis testing. There's no pre-employment cannabis testing in Philly. Next slide.
Even for sensitive, safety sensitive positions, Lisa?
Can you go back a slide for a second? So I'm glad you brought that up because I should have highlighted the full slide here. So if somebody is working a position that like they're operating a crane, right? And that what they're doing could significantly impact the health or safety of other members of the public. There are some very specific nuanced exceptions there, but your definition, even if you're in construction, your definition of safety sensitive could be different from the Philadelphia ordinance. So if you have specific questions about Philly, again, we could talk offline, but you have to review how Philadelphia defines safety sensitive, just as compared to your general practices. And it's not just going to be anybody who's on the job site. It's going to be more specific than that.
Thank you.
No problem. All right, next slide. Okay, you can keep going. We're just going to go through a little bit more quickly so that we still have time for everything because we've had some good discussion points. I did want to make sure to mention in terms of the training. So do you have a process? And I think Darren touched on this a little bit in terms of training managers. And Darren, I'd love to hear your perspective on this. But I've worked with clients sometimes on even creating like a checklist or a summary of different types of physical signs, speech signs, you know, how someone looks, how someone smells, how someone acts, their speech, how they walk, things that we think are really common sense, but in the moment, it can be kind of hard to like define and identify what's happening. Cause I know I've talked to people where they're like, I don't know, this guy, he just seemed really off that day. Like just something seemed off about him. He didn't seem right. And then, you know, he knocked into the ladder and like knocked over a whole pallet of stuff. And so we decided to send him for a drug test. And it's not that that's not helpful, but if we are training our managers to look for specific signs and examples of certain behavior that's likely to mean impairment and what that looks like, even if they don't have the checklist like available, you know, they're not carrying it around with them, but they're going to be thinking about that more in terms of like, okay, what am I actually looking for? And if I see something that seems off, what does that mean? How can I describe that better? So if we need to discipline or terminate someone or send them for fitness for duty, we have that evidence. So Darren, I was just wondering, because I think you mentioned, you know, working with managers for reasonable suspicion. Is there anything you would recommend or that you've seen to be helpful on that front?
Yeah, we actually had a representative from WorkNet a couple of years ago come in to train basically our superintendents, and you know, they were provided a certificate. It was a really in-depth training. I think it was maybe 2 hours, but I think the thing that really stuck out was, you know, if a person looks, or, you know, there's reasonable suspicion, and it's me who I'm looking at someone, I think that person is impaired. So I would actually ask, I think there's 1 or 2 other people involved in this process to validate what my thoughts are, and just to say, what are you seeing? Do you see the same signs? And just following those couple 2 or 3 steps, I think, is what the important part of the reasonable suspicion was, just to kind of hold up, you know, in situations where, you know, we needed to do something legally or from the insurance end.
Absolutely. And I think that's really helpful, and that's a great idea. And in an ideal world, we would have at least two witnesses who can say, yeah, that person was doing X, Y, and Z. It wasn't how they normally are. Here's what was different. Next slide.
Right. Hey, if I could just chime in real quick here, Lisa. This is Ty Reed. I'm the corporate safety officer for Butts. The training program that Darren was talking about was through WorkNet. Rita Lebo actually provided that training, and it was 2 hours. It was pretty in depth. But the other reason why you have to have a team is if somebody is under the influence, whether it's alcohol or whatever it might be, you know, the chances of them becoming combative is increased. So as a result, you just don't want to be in a room by yourself with that individual that you are potentially accusing of using illicit drugs. So it is a process. We've done it a handful of times. In fact, I will tell you that the job I'm on right now, I just found out a gentleman was removed from the job last week, unbeknownst to me, because he was in the job, Johnny, doing some things he shouldn't be doing. So it's alive and well, and that training is really, really important. So
Thank you so much for sharing, Ty. I totally
If I may?
agree. Yeah, go ahead.
Yeah, Lisa, this is John O'Brien. And also along with this training, there's a National Safety Council has impairment training. And they touch on, the need to have other people present, like the reasons Ty gave. But an additional reason is so it doesn't turn into he said, she said type of deal and so you get some more proof, But
Absolutely.
NSC has really good training as well. They do it online and in person. And I sat through it last year and it's good. It ties in HR and gives you documents and everything just to help you through the whole process and good stuff.
Great. That's great. And thanks for sharing. I'm just going to touch on one point here, and I think we're going to skip ahead to Tim's section. He has some really important additional insurance information to share with us from the insurance side, and I want to make sure we have time for Tim. So the one last thing I want to mention here, and then I'm happy to continue discussion afterwards or offline, is if you do have a situation with reasonable suspicion relating to an incident, we do want to make sure that we're testing anybody who we think could have been involved or contributed to the incident, not just someone who reported. That's a really specific OSHA rule because they want to make sure that we're not singling out anybody who's reporting a violation. So just know that if you have people in, you have 3 people who are working near a forklift and there's, a near miss or there's some sort of issue with the equipment or there's an accident, that if you think more than one person potentially could have been operating that forklift or been involved, that they're all tested and treated in the same way. And all right, John, if you wouldn't mind just skipping, I think we're going to go through a couple slides. I'll tell you when to stop. Okay, stop. Okay, Tim, I'll turn it over to you.
Sure, thank you. So some of this we talked about briefly with a question earlier. So for the most part, a claim is not going to be denied by the insurance carrier just because an employee was impaired. A couple other things that impact workers' comp are medical marijuana is not a covered medical benefit under the act or under case law, but what is impactful is that it is a reimbursable medical benefit. So the insurance carrier won't pay the doctors directly, but it will reimburse the employee if the doctor has it prescribed. So that's something that we're certainly we've seen some of that, certainly are going to see a little bit more of that as it becomes more prevalent. So again, that would have to be related to the injury, not just because someone took it previously for another medical reason. And then the experience mod, any workers' comp claim, any workers' comp costs are going to impact the experience mod. And there's a lot of contractors out there that have to keep their mod under one to bid work for certain general contractors or construction managers, or if they're doing work for the government, that's often a requirement. So, that's something just to keep in the back of your mind. It's certainly if there's an increase in claim costs or claim frequency, that painter who fell down the stairs because he was impaired, you may not be able to deny the claim, and that claim may impact your experience mod, which would increase costs going forward and potentially, your ability to bid work going forward. So, that's why one of the reasons why it's important to make sure we have good policies and procedures around this topic. And then, go ahead, Darren.
No, that's a great point. I was curious on how that impacts your experience mod.
Yeah, so it would be treated with any other claim. So if that claim is covered, in Pennsylvania, the cap is, I think, 42,500. So any claim that's within that would be included in the calculation, and that would stay in the calculation within a 3-year period. So for larger companies, one claim may not impact them, but for small and mid-sized companies, there could be a situation where one claim impacts the experience mod, and it could be over one for 3 years because of a bad situation like that.
So Tim, in the future, if they do come out with a test that can test if somebody's high at the time or impaired at the time of an incident, will you anticipate claims being denied at that point?
I would say you could have some claims denied, but there would still have to be the burden of proof that their impairment caused the injury. There's an example that we have a director of claims who was a former workers' comp defense attorney, and the example that he gave was if an employee is driving and he's drunk under the influence and gets in an accident, but it was snowing, the claim's not going to be denied because you had another intervening factor and you can't prove that the accident was a result of the impairment. So unless you can prove that the workers' comp injury was the result of him or her being impaired, then I'd say there's no chance of denial. And that case law is certainly going to develop over time as we see more of it. But again, Pennsylvania is very employee friendly. So it's going to be a tough hill to climb to deny a claim.
Geez, Tim, you just hit the nail on the head right there when you said Pennsylvania is a very employee leaned entity. We've had many of those situations, and I'll bet you in my career over 36 years, we're probably 1 for 30. If you follow what I'm saying.
Yeah.
It's just the unfortunate reality for us on the employer side. Pennsylvania workers' comp is probably, I know they're all bad, but this is probably one of the worst, and it's a shame. If you prove someone to be under the influence and they do create an issue that leads to injury and or equipment damage, it's awfully difficult for that not to be a claim.
Yeah. And then from a liability standpoint, their insurance companies can put any exclusion they want on a policy. So is it possible that we could see exclusions related to medical marijuana use? Yes, it's possible, but not something that's prevalent or what we've seen yet. But if you do have an employee, it doesn't hurt to reach out to your insurance broker and just ask them a question, tell them the situation, and ask if there's anything that's specific to their program that could have an impact. Punitive damage is one thing to consider. Pennsylvania says that punitive damages are not insurable, while other states, it actually is insurable. So again, another good reason for employers to be diligent around this is if you have an employee that has a known medical marijuana card and there's been instances of them being impaired on the job site or while operating a vehicle, and then they get in an accident, that could be a situation where the plaintiff attorney tries to get punitive damages against the employer because they were grossly negligent and didn't protect the general public and kind of let their employees run wild. So that's another potential takeaway and reason to make sure employers are diligent. And then we talked a little bit before about termination or discrimination. Employment practices liability is the insurance policy that'll cover all that. And again, at this time, we haven't really seen any specific exclusions related to medical marijuana. So if you would terminate somebody or discriminate against someone because they have a medical marijuana card or be accused of it, then that's likely a claim that would be covered under an employment practices liability policy. Not everybody buys them. They're available. So certainly we're happy to answer any questions on those. Next slide. And then kind of just a general overall impact, anything that increases claims is going to increase insurance costs, whether it's workers' comp or other lines of coverage. So keep that in mind. Obviously, the better job employers can do at reducing the claim severity, claim frequency is going to help keep cost control over time. And having impaired employees is certainly something that can have a negative effect. Companies can increase or decrease rates subjectively. So they can't non-renew, a business because they have an employee that has their medical marijuana card, and insurance companies can't enforce employers to do anything that's outside of the law. So they can't force employers to discriminate against their employees or not hire potential employees because they have a medical marijuana card. But they can increase rates for, a number of reasons. So it is possible that they could look negatively, but again, that's not anything we've seen. And then the last kind of two pieces of advice are seek advice from your loss control consultant for your insurance carrier and ask them for assistance. Same thing with your insurance broker. as far as crafting a policy. And different insurance carriers are going to have different opinions on things, and some have, kind of a wider reach than just Pennsylvania. So certainly that's our recommendation. And if there is a claim, a workers' comp claim or liability claim involving an employee that may have been impaired, certainly same advice, engage the claims adjuster and your broker early in the process. So,
All right. You all made it.
I have a quick question. So this is directed towards more of the insurance, but maybe even the legal side. If there's a is there an issue if an employee that has a Pennsylvania medical marijuana card works in another state that doesn't have a MMA law?
So
And-
so I just answering from the legal side, generally the rules that apply to an employee are the laws where the employee is working. And so if you have somebody who got a card in Pennsylvania, but they're consuming marijuana in a way that's not consistent with the state where they're working, and they don't have if they're working in a state that doesn't recognize medical marijuana, that could impact your assessment. But ultimately, we would still want to be cautious if they actually have a valid prescription, that we don't want to have any kind of disability discrimination related claims. So probably the best practice would be to assess the situation from the impairment perspective and not just jump to judgment based on test results. But in most cases, you follow the law of the state where the work is being performed.
Now, can insurance cover that then? If an employer decides to send someone that has a medical marijuana license, is that something that would be covered if that comes to light?
yeah,
If something happens?
Yeah, every state's going to have a little bit different law around workers' comp, and it's going to depend on, if he's Pennsylvania, if the employer's based in Pennsylvania, it's an employee who lives in Pennsylvania, he goes to Maryland for a day and then gets hurt and is impaired, it'd likely be Pennsylvania law would govern that. If he was hired he lives in Georgia, but he was hired to work in California but splits his time between 20 different states. Well, that one would be a fun one to figure out which state law applied, and it would likely be where the accident occurred. So, that the laws in different states are developing. So it's certainly that could be an impact, and it may not be covered in another state.
Thank you.
Any other questions?
If not, I have one. I think it will be an easy one here. Darren made mention about drug testing and doing the 10 panel and not testing for marijuana, so it's technically a 9 panel. I'm hearing from more and more employers that they're saying that we're announcing that we are drug testing, but they're not actually testing for marijuana. Do they have to announce that, or is that something that has to be known ahead of time?
That you're not testing for marijuana?
Yeah, correct. Do you have to let the employees know what they're being tested for?
Ultimately, yes, they need to know what they're being tested for. Yes, you do need to let them know, but I would say that it depends. Like, you don't, if you're putting, like, for example, on a application form that you do drug testing, you don't necessarily have to go into a lot of detail at that point. But when they go for the test, they need to know what they're being tested for.
Okay, because the comment I hear from employers is, we realize a lot of people are using marijuana, and this might scare some off, but.
Yeah. And so again, you don't have to necessarily broadcast like the details of your practice when you're just speaking about it broadly. But if they're actually tested, then they would need to understand what the test is what's included in the panel.
So Lisa, our organization is embarking upon a rolling CSIP. And part of that rolling CSIP, Darren had mentioned earlier about the notarized letter. Don't we have to put into that information, what it is that they should be testing for? Like we need to tell them it's not THC. Or do we not?
I apologize. I don't remember at what point that letter falls into your process. But yeah, so I guess what I'm saying is that when you describe what is, the makeup of your testing panel, yes, you should be clear about what you're testing for, whether it's THC or not. When you're just broadly telling potential candidates or new hires that we have a drug testing policy, we do periodic random testing, we do drug testing. You don't have to be specific there if you think that would be to your advantage. So if you think it's helpful to kind of weed people out at that point, you can be broader. But when you actually talk to your employees about, no, we're going to do this test, this is what we're testing for, you need to be clear about what the tests, what's involved in the tests.
Right. It's not only our own employees, but it's all of our subcontractor employees as well.
Right.
So yeah, and that's what we're doing. We're actually putting that in front end documents that says, look, it is a 10 panel, not necessarily 10, it's 9, like the gentleman said earlier, but just want to make sure that that's legal. It's the way to
We
go.
list out the 9, the 9 controlled substances. We just don't mention THC or marijuana in it as not being tested. So we just listed the 9, cocaine, opioids, amphetamines, etc. So we just don't mention marijuana.
That's fine.
And so we are recording this session, this workshop. So if you need to review, go over some of the questions that were asked, or if you need the speaker's information, it will be sent to you after this. But if there's not any other questions, I want to, on behalf of the KCA Educational Committee, I want to thank the speakers and all the participants for having a great session today.
Thank you, guys.
Thank you.
See you time.
Thanks, everyone.
Yep. Thanks to the panel.
Thank you.
And panel, can you stay on for a minute?